As you know, Congressman Taylor and I were selected by the Committee on Ethics to serve on this bipartisan working group to assist the committee in fulfilling its mandate pursuant to House Resolution 6. For those of you who may be watching this proceeding, public comments previously submitted by 5 organizations are available on the Committee on Ethics website at ethics.house.gov under the events schedule. There you will also find biographies of the participants. One quick update: due to a scheduling conflict, a representative from Issue 1, which did submit a written statement, will be unable to participate on the panel today. Each of the participants will have 3 minutes to make an opening statement, after which Congressman Taylor and I may have some questions for you. And before we get started, I just wanted to briefly introduce the 4 witnesses. We have Delaney Marsko, did I say that correctly, from the Campaign Legal Center. We have Donald Sherman from the Citizens for Responsibility and Ethics in Washington. Ben Hammer from govtrack.us, and Dr. Craig Holman from Public Citizen. Welcome to all of you. And before we get started, Congressman Taylor, do you have anything you'd like to add before we get started? Okay. With that, then, Ms. Marsko, we will start with you, and please give us your opening statement.
Great. Thank you. Thank you for that introduction. And thank you for allowing the Campaign Legal Center to participate in this important process. CLC is a nonpartisan, nonprofit organization that promotes an American political process that is accessible to all citizens, resulting in representative, responsive, and accountable government. CLC supports this committee's efforts to better address conflicts of interest arising from outside positions. The prohibition against service as an officer or director on any public company is an important first step. Our written comments more fully address how this committee can strengthen conflict of interest rules in the House, including by drawing on examples from state and local governments. I'll summarize those comments here. First, a member, officer, or employee should not hold any outside position with an entity that is specifically and uniquely overseen by a committee on which the member serves. This is because conflicts concerns are heightened when a member, officer, or employee oversees an entity in which they have a personal or financial interest. Massachusetts House rules recognize this conflict and prohibit a House member from serving on a committee where their private right is immediately concerned, distinct from the public interest. Before serving on a House committee, a member, officer, or employee should be required to resign from any position with an entity that is overseen by the committee, and then certify that they hold no such position and that they won't take such a position for at least the duration of their tenure. Second, a member, officer, or employee should not hold any position with an entity that has business with the United States government. Even if a member, officer, or employee does not directly have jurisdiction over an entity through committee membership, there's still a significant risk of a conflict if the entity has business with the federal government. House rules should make clear that a member, officer, or employee is also prohibited from holding a position with a federal contractor. New York City takes this approach and prohibits outside positions with firms engaged in business dealings with any city agency, not just the public servant's own agency. Third, the committee should consider extending the prohibition on public company board membership to other positions. A conflict of interest might arise even if a member is not an officer or director of a potentially conflict-producing entity. New York City's definition of position, for example, includes any officer, director, trustee, employee, agent, broker, or consultant. House rules should recognize that for those entities that may pose a conflict, a range of positions could implicate conflicts. Last, the committee should establish a clear, adaptable framework for assessing conflicts of interest arising from outside positions not specified in these new regulations. A clear, adaptable catch-all standard will prevent conflicts from slipping through the cracks. Several states and the federal executive branch have conflict standards that can be applied to many situations that might pose conflicts from outside positions. That concludes my comments. Thank you so much.
We will go to Mr. Sherman. We're going to hear from all of you, and then we will return to the question period. Thank you. Mr. Sherman, proceed.
Good afternoon.
Good afternoon.
I want to thank the committee for creating this bipartisan working group, as well as Congresswoman Wild and Congressman Taylor for the invitation to appear today. Citizens for Responsibility and Ethics in Washington is a nonpartisan, nonprofit government ethics watchdog committed to promoting government accountability and protecting the public from conflicts of interest across all levels and all branches of government. The Ethics Committee plays a critical role in ensuring that House members and staff abide by the highest ethical standards. It was my honor to serve on the committee staff under the leadership of then-Chair Zoe Lofgren and Ranking Member Joe Bonner, and now to have input in these ongoing efforts. As articulated further in our lengthier written submission, CREW recommends 4 general principles to guide the committee's approach to regulation of outside positions. First, an effective ethics program must aim to prevent conflicts of interest before they arise. Second, not all conflicts of interest are financial in nature. Third, the perception of a conflict of interest can be as harmful as the existence of one. Fourth, government officials in different positions sometimes need different ethics rules. For example, the committee recognizes that stricter rules may apply to members as compared to staff. Regarding the committee's interest in identifying specific types of outside positions that can give rise to conflicts, CREW believes that there are 3 types that this working group should focus on. First, as the committee knows well, closely held companies in which members of Congress maintain a role while in office have frequently given rise to ethics investigations. Unlike with publicly traded companies, identifying and preventing conflicts arising from closely held companies is particularly challenging, in part because state laws often shield such entities from publicly disclosing information about their creditors, investors, and customers. CREW suggests that the committee prioritize addressing conflicts arising from members and staff's ties to closely held companies. Second, positions with nonprofit organizations can lead to actual or perceived conflicts, particularly if the organization frequently interacts with the federal government via lobbying. As such, the committee should consider limiting members and staff's ability to hold positions with nonprofits that engage in more than a de minimis amount of federal lobbying. Lastly, CREW recommends that the committee consider imposing limits on the ability of members and staff to fundraise on behalf of non-political outside organizations. Fundraising represents a significant risk of improper influence and appearance issues that can undermine public trust. In closing, CREW applauds the committee for creating this working group and appreciates the opportunity to provide input for your consideration. This committee's bipartisan work to prevent conflicts arising from outside positions should serve as a model for how Congress can fulfill its mandate to promote ethical conduct at the highest levels of government, including the judiciary and the executive branch. We stand ready to work with you in any way we can, and I look forward to your questions.
Thank you very much, Mr. Sherman. Mr. Hammer.
Hello, thank you for having me here today. GovTrack.us is a web database used by millions of Americans every year to track congressional activity. It is host to the first ever congressional misconduct database, where users can learn about allegations and resolutions of misconduct by members as far back as 1789. Our position gives us an outsider perspective on the workings of the committee and OCE. While we hold a great respect for the challenging tasks these organizations face, we believe our perspective may be beneficial in understanding the optics of congressional ethics. In our letter, we made 7 recommendations based on 8 cases of allegations of conflict of interest misconduct selected from our database. Today, I would like to highlight 3 of those recommendations and the particular cases that led us to make them. First, the buck must stop with the member. Members must be held liable for the legislation they introduce, particularly when the member stands to gain financially, even if the member was not directly involved in writing the legislation. Ignorance of a conflict of interest should not be an excuse on behalf of the member. It should be the member's responsibility to be aware of the possible conflicts and actively prevent them. And the case that led us to this was that of Representative Roger Williams, who owns a car dealership that nominally rents loaner cars to customers having their vehicles serviced at the dealership. He introduced an amendment to legislation to exempt such companies such as his own from certain rental safety standards, allowing his company to rent vehicles subject to safety recalls. The amendment was accepted by voice vote. The committee concluded that Williams neither conceived nor drafted the amendment, which is further evidence that he did not introduce the Williams amendment to benefit himself. We believe a member should be expected to be aware of the legislation they introduce, especially if such legislation creates the appearance of a conflict of interest. Second, we recommend the committee address the frequent occurrence of members evading the disposition of matters. In 2 cases, a conflict of interest was found and OCE determined it was an ethics violation, yet the members faced inadequate repercussions. In the case of Representative David McKinley, he received a letter of approval for remaining a named partner in his prior business after being elected to Congress. He sold his business with the name intact rather than disassociate his name from the business, and the perception of conflict of interest still remains to this day. In the case of former Representative Alan Grayson, Grayson was investigated for numerous alleged violations, but the committee's jurisdiction ended when Grayson left office before a finding was made. We additionally recommend the placement of time limits upon which the committee's good graces can be relied on to avoid sanctions. Finally, we are concerned that conflicts of interest are not solely limited to the member themselves, but can also occur due to involvement from a member's immediate family, such as their spouse. In the case of Representative Mark Wayne Mullen, Representative Mullen was investigated for serving as a board member of his family's business. We note that Representative Mullen began working with the committee to get into compliance as soon as he was elected. Our comments are not about his specific behavior, rather they are about what constitutes the removal of a conflict of interest. Representative Mullen transferred ownership of the business to his wife. The committee identified an improper payment to a joint bank account held by Mullen and his wife and directed that it be returned, upon which the matter was closed. We were struck by the committee's acceptance that a transfer of an asset to a spouse was a meaningful distinction, and by the extraordinarily long time it took Mullen to exit his family business and for the committee to resolve the case relative to the already short 2-year duration of a member's term in office. We believe transferring ownership of an asset to a spouse or a close family member does not remove the conflict of interest. But while the committee forced the payment to be returned from Mullen and his wife's joint bank account, they seemed satisfied by the transfer of stake in the company to his wife. Thank you very much.
Thank you, Mr. Hammer. Dr. Holman.
Thank you, co-chairs Wild and Taylor, for giving me the chance to testify. This proceeding is in reaction to a change in the House rules under House Resolution 6. In reaction to the insider trading scandal associated with Chris Collins, the 116th Congress decided that they would institute a rule to ban members from sitting on publicly owned corporate boards, pretty much following the Senate rule. I was encouraging the sponsors of that legislation, as well as the Rules Committee, to go a little further and actually prohibit members from sitting on for-profit corporate boards, not just publicly owned, because they offer the same conflicts of interest. At that time, Chairman McGovern of the Rules Committee wasn't willing to go that far, but he did include in House Resolution 6 an instruction for the House Ethics Committee to take a closer look at this and see if there's something that should be done. I would like to again urge you to go a little further than publicly owned, than banning members from sitting on publicly owned corporate boards. The same types of conflicts of interest apply to for-profit corporations. And so I encourage you to take a look at extending the ban to for-profit corporations across the board. Now, a recent study by the New York Times, which they haven't published yet, but it's going to be published soon, found that very few members actually sit on publicly owned corporate boards, but many, and they documented at least 60, sit on for-profit corporate boards. Most of those are LLCs. Now, LLCs pose a unique and troubling concern that I would like you to address. They offer, in many cases, the same types of conflicts of interest, but in other cases, LLCs simply provide legal protection for personal property or even investment funds. So it's an issue that needs to be addressed as to which types of LLCs may pose a conflict of interest that should be captured under a broadened rule that addresses for-profit corporate boards. So those, and at the very least, if you can't come up with a reasonable way of determining which LLC provides a conflict of interest, at least require broader disclosure of all the members who are sitting on any particular LLC that involves a lawmaker as well. That way we can determine if there's a conflict of interest. And very quickly, since I'm running out of time, one more thing that I've been encouraging Congress to undertake is extending the rule against stock trading activity to include the same type of rule that Congress imposes on the executive branch. If you sit in a position that oversees a particular industry or business, you should not be allowed to trade stocks in those businesses. And I would encourage the committee to take a look at that issue as well.
Thank you very much, Dr. Holman. I am going to propose to my co-chair that he and I go back and forth and in a somewhat informal way. One of us may have follow-up questions, but I'll let you start, Mr. Taylor, and we will proceed with questioning.
Thank you, Representative. My first question was regarding, Ms. Marsko, going back to you referenced it in your written testimony in your third footnote, and then you also mentioned again today the Massachusetts legislature and their House Rule 19A14. So that rule or language like that applied to me when I served in the Texas House and in the Texas Senate. It's actually in the Texas Constitution. It's actually in Rule 3 and I believe Rule 27 here in the U.S. House of Representatives. I think it's interesting that you picked Massachusetts. Did they have some particular interpretation of this rule that is different from the way that it's applied in other parts of the country?
So thank you. We included that because we just thought it would be a useful example to point to the ways committee membership can be the source of a conflict of interest, and not necessarily that this language is singular as against the rest of the country, but just kind of illustrating the idea that other legislatures have seen the potential for conflicts of interest by virtue of serving on a committee and having a private interest conflicting with that oversight.
So the way this was interpreted in Texas and the way I understand it's interpreted in this chamber is that a member cannot vote on something that directly helps them. So their name, a company they own 100% of, if it's helping in a very specific basis. If they're a taxpayer and they vote on taxes, that's okay, is the way that it's interpreted in Texas, and I understand that it's interpreted here. Does Massachusetts do it differently?
Not that I know of. And
okay.
our suggestion is, when the broader sort of proposal is.
I think you've answered my question. I was just trying to figure out why you brought them in,
Yeah.
given that we're already doing it here. Right. Thank you.
I'm going to follow up with Ms. Marsko. The conclusion of your written comments, and I believe your oral testimony, talked about the need for the committee to provide clear, workable standards to assess conflicts of interest that members, officers, and employees can readily apply to their outside activities so that we can evaluate scenarios that are not explicitly mentioned in the final regulations. And I think that is a laudable goal. I think we would all like to have clear, workable standards. Sometimes that's overly aspirational, because until we're faced with a specific situation, it's hard to contemplate what standards might apply. But my question for you is whether CLC has any proposals for clear, workable standards to assess such conflicts of interest.
No, but we would love to have you guys come up with something that works really well. I think in terms of that suggestion, I think sometimes when you provide a list of things that pose a conflict, it has the specter of anything outside of that list is not conflict producing. And so the suggestion is to have something potentially like 5 CFR 2635 subpart H, which is the executive branch outside position regulation, that says if anything would raise questions of your impartiality to such a degree that you would have to recuse from something that is integral to your work, then that you can't have that outside position, or like how some other states provide factors to consider, so that if something is coming up, that the the members are on notice that they have to consider these particular factors.
And along those lines, you mentioned specifically in Kentucky, public servants are provided a list of 5 considerations designed to help them determine whether they should recuse from an official decision. And I don't have that statute in front of me. Do you happen to know what those 5 considerations are?
I don't have.
Okay.
Yeah, I'm sorry.
All right, thanks. Mr. Taylor?
Thank you. Mr. Holman, thank you for your testimony. I thought it was particularly addressed to what we're dealing with, which is positions. And that's really what this hearing is about. What the two of us are trying to do is figure out which positions, in addition to the ones who are already prohibited by our colleagues, Representative Rice and Representative Reed of New York, in their amendment to the House rules in the 116th Congress. And thank you for giving us some insight. I was curious on footnote number 4 when you said there's a forthcoming New York Times article, and being a subscriber, I was just kind of curious what was next. So thank you for illuminating this forthcoming article. I look forward to reading it.
So do I.
And I just wanted to say, you focused in on limited liability companies. And so LLC owners usually don't have management. That's usually done by the manager of the LLC. And so, it sounds like you're distinguishing limited partnerships where the owners, people that own pieces of a limited partnership, have no operational control whatsoever. It's the definition of being a limited partner. It's why they have limited liability, right? They have no control over the business, over whatever the partnership is doing. The general partner has control, right? So, is there a reason why you didn't mention C corporations? I mean, why are you honing in on LLCs?
I was using the New York Times database. They were the ones that told me that the LLCs tend to be the predominant type of for-profit corporation that lawmakers participate in.
Right.
So that is why I only went that far. And I took a look at the structure of LLCs, and they're structured differently. It all depends on the particular charter. Mm-hmm. And I see that most LLCs really do not pose a serious conflict of interest, but it certainly appears that some can be structured in a for-profit business type of relationship that could pose a conflict of interest. And I'm not familiar with the structure of Cs, and so that's why I did not address that.
Okay. So, and I mean, I would guess, I haven't looked at this, that most of the LLCs is a result of an individual, in this case members of Congress, putting assets in the limited liability company and then using that as sort of an investment vehicle to then control maybe stocks or bonds or limited partnership ownerships. And so that's why you're probably seeing a higher ownership interest in LLCs in Congress. And I think you'd probably see that for sophisticated investors using that as kind of an investment vehicle rather than owning personally interest in limited partnerships or in stocks. They would do it through that LLC vehicle, but it's interesting that I'm glad you've explained why you honed in on that.
I did want the New York Times to share their complete data with me, but they wouldn't do it. They just gave me a snapshot picture.
Sure. Well, and we have actually looked at every position that every member of Congress has reported in the last Congress. So we did a full, it's a really long read, but we were trying to get a sense of what members of Congress are doing, what their interests are.
That's great. Thanks.
Thank you. Mr. Sherman, I'd like to direct my next questions to you. I found Crew's written comments to be very interesting and thought-provoking and helpful. I think, although it's all a matter of the record, since some people may be viewing this hearing, I did just want to commend the 4 general principles that you included to guide our approach to the regulation of outside positions. Those being, first, that the core goal is to prevent conflicts of interest before they arise. The second, that not all conflicts of interest are financial. The third, the perception of a conflict of interest can be as harmful as its existence. And the fourth being that government officials in different positions need different ethics rules. And I think that those really are sort of the framework within which we need to do our work here. I'd like to flesh out a little bit this, the second criteria, that not all conflicts of interest are financial. And I know that you did address it in your written comments, but for everybody here, could you elaborate a little bit on conflicts of interest that might not be financial in nature?
Absolutely.
Thank you.
Thank you for the opportunity. So one clear example is when a member or a staffer has a fiduciary duty to an outside entity in addition to their, what I think everyone agrees should be their primary duty to their constituents and to this body. And, you know, the committee has already recognized that members should not have paid positions where they have a fiduciary relationship other than that, their duty to the House and to their constituents. But certainly, for example, if a member or even a junior staffer, for example, was on the board of, let's say, an education nonprofit. Both of you all sit on the Education and Labor Committee. If they have responsibilities over a fiduciary relationship with an organization that regularly lobbies Congress, regularly lobbies the Department of Labor or the Department of Education, that organization's priorities and that member or staffer's relationship with the outside organization lobbying the federal government could directly conflict with their role as a federal employee in the United States Congress.
And could you just, I'm a lawyer by training, so I obviously know the legal definition of fiduciary, but just in the context that you use it, describe for us what you mean by a fiduciary relationship. Say in that example you gave of a staffer that has a relationship with an educational institution.
Certainly. Well, in short, it represents someone who must take actions in the best interest of the entity with which they have a relationship. I think it's easy to imagine a scenario where taking steps to support the best interest of an outside educational nonprofit might conflict with their job, which is to take steps consistent with the representational interests of their members, constituents, and of the committee on which they serve.
Okay, thank you. Mr. Taylor?
Just to build on that, just so I'm kind of clear, but so if one of my staffers is a scoutmaster, right, does that create a conflict?
I am hesitant to sort of opine on hypotheticals, but I think there are certainly reasonable accommodations that can be made, and I think conflict doesn't necessarily exist in every particular relationship. I think, one, it would depend on what is the staffer's role with the Scouts. You said Scoutmaster, so I doubt that that would conflict with their role, but if they were on the board of the Scouts, that could potentially, and depending on their responsibilities in your office, that could conflict with their role. You know, the outside position could conflict with their role on your staff as a congressional employee. You know, I would point out that there are sort of common sense examples where there aren't conflicts. I would note that your predecessor sat on the Board of Regents of the Smithsonian Institution, which, you know, obviously is sort of a public-private entity.
But there are, I mean, members of Congress are supposed to sit on that board, right?
Yes, I agree. What I'm saying is,
Is that a conflict of interest?
that isn't a conflict of interest.
That's not.
Right, and I think that the committee can draw broad rules that, much as they have with the gift rule, that outline a standard, exceptions, and provide clear examples so that members and staff can avoid even the appearance of a conflict of interest.
Can we agree that if you're in a nonprofit in whatever capacity, there cannot be a pecuniary interest?
Absolutely.
Okay,
Well,
so we could, but there's no financial interest if you're.
I don't believe so.
Right.
But again,
Which, I mean, we should point out that the heretofore, members of Congress could not be a paid board member. So the pecuniary, in theory, the pecuniary interest was removed because they could only be an unpaid board member, right? So there's no pecuniary interest.
Again, but yeah, I agree with that. Again, I would point back to the guidelines or to the principles that we identified, which is that you don't necessarily need to have a financial interest to have a conflict of interest, particularly when there's a relationship where you're supposed to act in the best interest of one entity as well as another one, and those two entities, in this case the House and the outside position, may not be compatible with each other.
If a member of Congress has a family member that died from a rare disease, does that then create a conflict of interest that then that member of Congress is animated to try to get an NIH funding grant to try to fight that rare disease? Is that a conflict of interest?
I wouldn't say that's a conflict of interest. I would say that is life experience that informs their perspective on particular legislation, which I think is why members are elected.
All right, thank you, and that was well said.
Mr. Sherman, I'm sorry to keep you on the hot seat, but we're going to stick with you for just a moment. One of the things that you also mentioned in your written comments is that positions that involve fundraising for a non-political outside organization have that potential to create a conflict of interest. And it's short, so I'm just going to read it quickly. Your written comments say, regardless of the type of organization, CREW suggests that the committee consider whether specific limits on positions that involve fundraising on behalf of a non-political outside organization for categories of House members, officers, and employees would be appropriate. Such positions present a particularly high risk of improper influence and almost certainly present appearance issues that members, at a minimum, should avoid. I guess before I ask you anything, I wanted to see if any of the other members of the panel have any disagreement with that as a fundamental principle, that statement that I just read. Okay. I agree with you, Mr. Sherman, that if fundraising of any type outside the political realm, certainly by a member, creates a unique set of circumstances that may cause people to feel that they must contribute or at least to be more influenced than they would be if somebody else asked them. So let me just take that to its outermost limits, okay?
Sure.
I recently had occasion to do a birthday fundraiser on Facebook, on a personal Facebook page, not my political or official, but to support a cause that I very much believe in. After reading your comments, I questioned whether that was a sensible thing for me to do. So let's just talk about that scenario. Do you think that would be violative of what you're recommending here? And I won't take offense if you do, because I really would like an objective answer on that.
Certainly, I think in accomplishing your task, you have to balance the risks of a conflict of interest with the potential burdens, and if there are unreasonable burdens on members, staff, and frankly, private individuals. I would say, though, that moneyed interests, as an organization that is concerned about money in politics, moneyed interests are always looking for ways, legal and otherwise, to influence members of Congress, and donations to even nonprofit organizations is a way that moneyed interests try to curry favor, access, and influence with members of Congress. What I would say is that I would be incredibly thoughtful about how and in what form you engage in that activity, regardless of the rules, because it has the potential to raise questions about who is trying to get your attention and through what means they're trying to get it. And obviously, your time and your attention are valuable and are meant to, and you are elected to provide your time and attention to your constituents. And I would say that this is a potential opportunity for unscrupulous individuals to use a seemingly innocent effort to raise money for a nonprofit to circumvent the democratic process. And I think the committee should look at those avenues and, again, weigh the risks of a potential conflict versus the potential burdens. I think it's great that, people fundraise for causes that they believe in, but not at the expense of undermining public confidence in our government.
I completely agree with that last statement. I would be somewhat concerned about a blanket prohibition on non-political fundraising for outside organizations. I do think that we can use our rather public platform to advance some causes without it necessarily creating a conflict of interest. But I do think that there's that it has to be very carefully evaluated. You're not suggesting that there be a blanket prohibition on that, are you? Or are you?
I'm not suggesting that there's a blanket prohibition. One of the things that I cited to in the written comment was the Judicial Code of Ethics, which provides rules and limitations with respect to how federal judges can fundraise. Some of those limitations include that they can fundraise from other judges, but certainly not from people in their family, but certainly not from the general public, and obviously not from folks that are likely to appear before their court. I think that rule may be a good starting point for consideration, and obviously, as I said, you have to sort of weigh the risks versus the burdens. But there is a model for this in the government, and the judiciary has a useful one.
I think the judiciary has a somewhat different set of circumstances than we legislators do. Candidly, I'm not sure that I would find on this particular issue the rules for the judiciary to be particularly guiding for us. But your points are well taken and very thought-provoking, and I appreciate them. I think it's something that we all have to be careful of, because in today's times, especially with the proliferation of social media, there are always opportunities to jump onto bandwagons, some of which are for very worthwhile causes. So thank you for that. Mr. Taylor, I'm going to turn it back over. Oh, sure, Mr. Sherman, go ahead.
I fully concede that the judiciary and the legislative branch have different roles and responsibilities, that those differences should inform your approach here. One thing that I would point out, though, is that in the judicial branch, judges can recuse from cases where there is a conflict of interest, whereas recusal by a member of the House obviously adversely impacts their constituents in a very real way,
Sure.
and is not really what the Constitution contemplated with this branch of government. And so I think those distinctions do matter. I agree with you.
Thank you. Mr. Taylor, you're done? I have a couple of other questions that I wanted to ask. Okay, and I'm going to try to wrap them up before we get called for vote so that we don't have to adjourn and come back. I'm going to direct this to Dr. Holman, just to give Mr. Sherman a break here. But anybody that feels that they have information that would be helpful to answer this. One of my concerns, and I'm very concerned about the LLC issue that you mentioned, and I would propose at a minimum that all partners in an LLC should have to be disclosed on our financial statements, rather than just mentioning the LLC. I do think that's appropriate. But, the comment has been made that I've heard from a number of people that we don't want members of Congress to only come from one walk of life, and that we want diversity among our ranks, and that includes people who are in the business world, entrepreneurs, people who may be involved in family-owned businesses and that kind of thing. So I guess my question is, do you propose that all of those people in those categories should not be serving on the board of a privately held corporation or an LLC?
I do
Or as
not
a
go
member
as
in an
far as to say LLC, because I've recognized that many LLCs really don't pose some sort of self-serving interest. When it comes to private corporate boards, I do universally agree that a lawmaker should not sit on a private corporate board. That provides, the two inherent conflicts of interest. One, it provides the lawmaker with special inside knowledge of what's going on with the corporation, even if he or she is not getting paid serving on that corporate board. We saw that with Chris Collins, for instance. And the second conflict of interest is serving on the corporate board does raise the fiduciary responsibility, which can compete with the primary responsibility of a lawmaker. So I would encourage you to prohibit sitting on any private for-profit corporate board. And LLCs, I understand they've got to be broken down as to those that actually pose a conflict of interest.
And the number that you cited before that I guess is going to come out in the New York Times article, that at least 60 members of Congress are associated with more than 100 for-profit companies, particularly LLCs. That would include privately held companies as well as LLCs?
Yes, it does.
But does it exclude publicly held companies because of the new rule?
I was told by the New York Times that they could only identify one member who sat on a publicly owned corporate board.
So the vast majority of these 60
Yes.
are either LLCs or privately held?
corporate boards, yes.
Okay. I don't think I have anything else, do you, Mr. Taylor?
I just want to thank the participants and my colleague here. This is the most fun hearing I've had in the U.S. House of Representatives. It reminds me of the Texas legislature, where we're here to just get things done and answer questions, and just appreciate this format, and really appreciate the time and effort you put into this. And I look forward to your additional input with additional steps. And I hope that you understand that our task is very narrow. We're here to deal with positions. And so there are some things have come up here, and certainly in your writing, even more things that just, I think, are outside the box of what we've been asked to look at, and what Rule 6 was really designed for us to go after. But I just appreciate you all being here. Appreciate my colleague.
If I may just have a moment, I want to consult with staff for 1 second. Thank you. I just wanted to consult with staff to make sure I wasn't going to run afoul of their rules for us. I wanted to invite the four of you, to the extent that you have any additional comments that you want to make based upon what was said here today, either by one of your co-panelists or in the question and answer session, to feel free to do so. We would ask that we have your additional comments by the end of the second week in August. As committee staff will be working on a proposed rule and would like to incorporate those comments if you have any. Don't feel compelled to. I'm just giving you that opportunity as opposed to inviting you to discourse further today. With that said, I thank everybody who showed an interest in this topic. Congressman Taylor and I and the committee staff have been very dedicated and devoted to this subject, which I think is incredibly important for for the public's faith and trust in Congress, and we're hoping to move forward rather quickly and create a rule. So with that said, this public session is adjourned. Thank you very much.
Thank you.